Hello, everybody, if there is anybody. Gonna go tweet out that I am doing this. Gonna go tweet out that I am doing this. Gonna go tweet out that I am doing this. Gonna go tweet out that I am doing this.
Hey, James.
Gonna go tweet out.
Yeah, I guess I'm a couple minutes early.
Doing this.
Hey, James.
Gonna go tweet out.
Yeah, I guess I'm a couple minutes early.
Doing this.
Hey, James.
Gonna go tweet out.
Yeah, I guess I'm a couple minutes early.
Doing this.
Okay. Yeah, give people a second. Yeah, that was weird. I was like listening to myself. I think my YouTube is like playing into the, like I had play sound from browser on, so it's just looping because I had my own window open. Hey, Matthew. No roll call. I was kind of sad we didn't. I was listening to the Justice Served thing. I was sad we didn't get to talk about Tyrone Blackburn. I was really hoping. I was hoping there'd be like a Q&A. I had some questions ready, but oh well. Hey, Big Clipper. Anyway, yeah, so the case we're looking at today is actually a case I cited. I think I cited it in some Moonting's briefing. I know Brian Steele cited it in his briefing when the state tried to revoke Young Thug's probation. Email question. I should. Did they mention Aaron Hernandez? I don't think so. Was he involved in that? I mean, my questions also aren't like appropriate, so I don't think they get chosen. I just have to try to sneak them in through the chat. Like, Wendy was, yeah. I thought I remember her saying something. She said some things that are questionable in the past. Not that that's relevant to the guardianship thing. Oh, really? All right. I guess I'll get started. Don't make the big city lawyers mad. Also, she's representing... Wait, really? I didn't know that. Her husband's involved in Epstein? Man, it feels like everybody's involved in Epstein at this point. My goodness. Is probation a form of double jeopardy? Oh, no, it's considered part of the first sentence. Of the initial sentence. I think that the logic is that you could just put, like, say you get 10 years of probation, you could have just put them in prison for 10 years. So probation is like a lesser punishment. She's representing. Yeah. That's what's her face, right? Linda. I thought you were talking about Wendy. I was like, Wendy's representing Turtle Boy? I would watch a talk show of the two of them together because they're both very emphatic. They are two very emphatic people. I can only imagine what would come out of that one. I would pay to see that. Head down to the Bach Theater, sell it out, $150K. Okay, probably like two of you get that, so I'll limit the references. I would need for calling. Oh man, I listened to my very first Turtle Boy Spaces yesterday. It was an experience. That was something new for me. Very entertaining. Oh my goodness. I feel like I should just go do a review of that now. Instead, we're going to talk about probation revocation. Very exciting. So I just need to get, yeah, they were deep cuts. I need to show this one little boring part first, just for context before we go into the other stuff. It won't really make sense if I don't show this part first. This is just the statute that allows for probation revocation, and it's really an issue in this case. So I just want to show this first. A court, that's important. It will be important later. A court may not revoke any part of any probated or suspended sentence unless the defendant admits the violations as alleged, or unless the evidence produced at the hearing establishes by a preponderance of the evidence the violation or violations alleged. So, not to give everything away, but the a court part is important because this is a restriction on the court, really, as opposed to the defendant. It's directed at the court, really, even though it relates to the rights of the defendant. A court may not revoke any part of any probated sentence. So, with that in mind, we're going to switch to the oral argument because that's fun. One more thing I need to say. Let me hide my tabs so I don't get made fun of. There we go. Hey, Lee. Okay. One more thing that will explain some of the struggles in oral argument that both sides have is that the Supreme Court told them to focus on a due process question. Let me see. Will this be on the final? Oh, no. I'm just gonna... It'll just be a pass-fail, yes or no question. And the question is question mark. That's not really a question, but, it's a hypothetical test anyway. Okay. Actually, you know what? I am going to show you one more thing before we get into this, just so you know what the case is about. I want my probation. Yeah, there actually was. There's a Fulton case recently in the Supreme Court. I almost showed that instead. There we go. So I'm not going to read the whole thing. I'll just give you a little bit of a briefing on it. So this is the appellant's brief. So the state lost at the Court of Appeals, so they're actually the petitioner here. Basically what happened is that there's this guy, Greathouse. I think he got convicted on, possessing less than 2 grams of meth, and one count of possessing a drug-related object. I'm guessing it was a pipe, which feels kind of redundant, because really the meth is the problem, not the pipe. You don't have the meth. The pipe's not even like a drug-related object anymore. But anyway, he was put on probation. He violated probation like 4 times, I think. They're going to run through the various steps here. He was repeatedly violating probation. To be clear, this guy definitely violated probation. So that's not even the issue here. Let me see. Here we go. This is the last part here. So after the last violation, I think it was the 4th violation. Let's see. He prospectively waived any constitutional or statutory right to a future hearing on the matter, stipulated in advance to immediate execution of the suspended sentence upon a judicial finding of probable cause. So in theory, the state's theory is that what he did is he waived his rights under this statute. That he had a right to a hearing under this statute here, and he waived that. And you're allowed to waive your rights to these sorts of things. Let me see. Okay, here on April 3rd, 2024, William Gibson, a community supervision officer, Department of Community Supervision, formerly known as the Probation supervision, applied for and obtained a probation warrant on the ground that respondent had left his residential treatment facility without first obtaining his probation officer's leave to do so. Supposedly he had diabetes and he was being treated, and that's why he left. I have no idea if that's true or not, but that's what he said. That same day, the trial court, after reviewing an affidavit submitted by Officer Gibson, executed the suspended sentence and remanded respondent to the custody of the DOC. I should show you. It's actually the same statute for probation and suspended sentence, and the law applicable to probation revocations almost always applies to suspended sentence. You can use them interchangeably in most cases. So he had a violation. Rather than get sent to prison, he agreed to waive his right to a hearing if he had another violation. He supposedly had another violation, and his probation or his suspended sentence was revoked without a hearing. That's where we're at. Now, so, and again, on appeal, the Supreme Court specifically told the lawyers that is a due process question. So they're going to be discussing due process a lot. So, don't be too harsh on the lawyers for focusing on that when it's not necessarily the most relevant thing. But, okay, here we go. Oh, let me know on noise, too. There's none yet, but there will be. I say, I violated probation. The DA tried to give 2 out of the 5 years. Judge asked if I found guilty. I said no. Yeah, that's actually an interesting thing. I had a client with that right now. He was charged with 5 things in connection with probation revocation. And they dropped 4, and then the 5th charge was just time served. Told if I'm guilty, he would. Yeah. Judges don't have to do that, though. It's a lower standard. They can revoke just on a preponderance of evidence. So you can get situations where somebody's actually acquitted of a crime, but then they're revoked based on that same crime, even though they were acquitted, which is kind of messed up. Yeah, this argument was... I thought this case was really simple, but the argument is kind of interesting. Because of the lawyers didn't quite know what they were arguing about. As you'll see any second now, once this video starts playing. Oh wait, I need to play live chat, don't I?
Mr. Fuller, you may proceed when ready.
Chief Justice Peterson, Justices of the Supreme Court, thank you for your time.
Because we're on Vimeo, I gotta boost it instead of the YouTube way.
This morning, and may it please the court. This honorable court should correct the decision from the Court of Appeals in this case because the state's position is consistent with federal and state law, and the Court of Appeals decision is inconsistent with the decision.
And again, this is the state going first. Usually it'd be the defendant, but the state lost on appeal. So now they are in the position of the opponent.
Decisions of this honorable court and its historical approach to due process and waiver of rights. That is because a defendant may prospectively waive constitutional or statutory rights to a probation revocation hearing in the event of a subsequent violation of the terms of probation. And Greathouse and his representative here today can show no legal basis for saying a probationer cannot waive those rights. If one is to think about the sentencing option waiver in this case as a house, the roof to that house would be the Thomas v. State case. In that case, it held that if there is no constitutional, statutory, or public policy prohibition against waiver, an accused may validly waive almost any right. And then the floor and foundation would be what we had shown in our...
Hold on a second. I gotta make it a little louder for me. I can't hear good.
Brief that there's a background in our statutes that if the legislature is going to limit us and say you can't prohibit our ability to waive a right, they're going to put that in the statutes. And we showed about 7 statutes where that's the case. This is also in line with the Zedner and Ricketts cases that this court was concerned about. In Zedner, Justice Alito in that case said that the issue in waiving a right there was the concern that this would impact third parties or the public interest. In this case, we have the reverse of that in the sense that this is only impacting the person who is considering that sentencing option waiver, and it goes for the public interest because it gets more people into treatment and gives that sword of Damocles over them to ensure that they complete treatment.
Okay, that was the first thing that annoyed me. He says that having somebody with a probation revocation waiver is a sword of Damocles over their head while they try to complete treatment. Bro, having a sword of Damocles over your head is not a great way to complete treatment successfully. That sounds like the opposite of a good way, but nevertheless.
It's in line with Ricketts because the concern there for Justice White was that it's voluntary, intelligent, and knowing. And then there's a persuasive case with Domka out of the Seventh Circuit that had a similar waiver of the hearing and the right to notice.
Yeah, I will say it is odd that they even went to the Supreme Court because, like, I think they had enough to revoke his probation. They could have just, like, dropped the point and then just gone back and revoked him. It's strange that they're even fighting this.
In a DUI sentencing case, and the Seventh Circuit said that that was constitutional.
Counsel, I'm sorry. Counsel, why isn't there a public policy concern here that we don't throw people in jail based on allegations that have not been addressed by the court or considered by the court? I mean,
that's a good question.
Here, Mr. Greathouse contends, and there wasn't hearing, so it's not in the record, contends that the reason he left the facility was because he wasn't being treated for diabetes and that was a medical issue for him. I mean, why isn't that a matter of public policy? We don't let judges throw people in jail without some sort of hearing or right to be heard.
Yes, Justice, thank you for your question. I think with the sentencing option waiver in this case that Greathouse opted into, part of that conversation was this would be if he was to fail the treatment program, there would be a conversation with the judge. There would have to be a probable cause that's spelled out in all the paperwork that he would have reviewed and signed.
Well, let me ask you about the waiver. What were the circumstances?
Hello?
Of this. I mean, it doesn't, we can't tell if it was done in open court, that the court explained it to them, and the only thing it was witnessed by, it looks like maybe the probation officer. So how is this court supposed to determine whether or not he even understood what he was signing to waive his rights?
Oh man, it's not so fun when you don't have a developed record on your side, is it? Is it, State? Shoes on the other foot now, isn't it?
Voluntarily,
You'd
intentionally.
love to see it.
Yes, Your Honor. And for the sentencing option waiver, this happens in a number of different ways. This can happen in open court in some cases. In this case, it was paperwork, and I can
Oh, this part straight into my veins, by the way. The next, 2 minutes.
show the court with the permission on the Elmo what that paperwork was. Essentially, the probation officer goes specifically over what those rights are given up. We actually have parentheticals when it
But
says.
how do we know that? It's nothing in the record to indicate that, is it?
Well, part of that, part of the record are the challenges that Mr. Greathouse had to this case. And so those challenges, if there is an issue they didn't understand their rights, or there was an issue with the treatment program, I think it would follow a very similar situation to what happened in this case.
Counsel, you mentioned that the statute doesn't say anything about waiver.
I love Andrew Pinson.
Doesn't it though? I mean,
we need to slide over so you can see Andrew. Here we go.
The statute says a court may not revoke any part of any probated sentence unless the defendant admits the violation.
Sorry, I need to hear that. Doesn't it, though?
Doesn't it, though? I mean,
In this case.
Counsel, you mentioned that the statute doesn't say anything about waiver. Doesn't it, though? I mean, The statute says a court may not revoke any part of any probated sentence unless the defendant admits the violation as alleged or unless the evidence produced at the revocation hearing establishes evidence of the violation. I mean, that seems to contemplate circumstances in which the defendant is presented with, here's how you violated your probation, and then the defendant at that point has a choice. Admit it, and there's no hearing, or you have a hearing and we'll prove it. It seems like that, I mean, putting aside due process and all those other things, it seems like the statute lays out precisely what the procedure is in these circumstances.
Okay, so this is kind of what I was getting at earlier. Let me switch to, I'll show you the statute again. Yeah, so he was citing this part, and he's saying the due process doesn't even really come into it. I mean, it can eventually, but it doesn't here, because a court may not revoke any part of a probated or suspended sentence unless the defendant admits the violation as alleged or unless the evidence produced at the hearing establishes a preponderance of the evidence violation. So it's not even really up to the, like, waiver has nothing to do with it. It has to do like what the court's allowed to do. And so, again, that's the point that Pinson's making there.
And in doing so, does not contemplate that the probationer could admit violations in the future that had never happened yet, right? Why doesn't the statute expressly contemplate that that's the time at which you make that decision? And there is essentially a waiver decision.
That's just the legal text. How is that governing? Yeah. Oh man, it is always funny when the court's just like, hey, there's this. They just read the law to you and like, isn't this enough? Why? What are we doing here?
But it's at the time that they're presented with the violations and not before.
Yes, sir. I think the answer to that question is that is the mechanism specifically spelled out with the statute. The question then is that at that point, is the state supposed to read that statute as an anti-waiver provision that you can't give up that right?
Well,
Is it their right to give up? Is that a right that belongs to the defendant, or is that an obligation statutorily imposed?
Okay, captions are kind of doing me dirty here. Disregard the captions. I did not write these captions. I did not approve these captions. I mean, I kind of, this one's kind of funny, but yeah, it's this is actually a very simple case. It's just the I'm kind of got one laugh out of that. It is a simple case. It's just the statute provides for revocation in a specific way.
It says shall have a hearing.
And so I think when we look at the rights, especially going back to Thomas v. State, Thomas v. State is holding that principle that most of the...
I will say, in fairness to the lawyer, again, he was specifically told to argue due process with respect to the prospective waiver. So, like, the court did tell him that this is the issue they wanted him to talk about. So they are kind of throwing him a curveball and that they're, like, switching topics on him now. But,
these rights that defendants have can be waived.
Well, so if we're in the space of reviewing a decision by the Court of Appeals that...
Oh, speaking of emojis, Kat and I, so there's, you may know this, but there is there's a specific Ninth Circuit judge that we have both looked very fondly upon with his facial expression. So I think that's going to be my first one. He looks kind of like an older Popeye.
We're in the space of reviewing a decision by the Court of Appeal. If we're in...
Can be waived.
Well, if we're in the space of reviewing a decision by the Court of Appeals that said due process prohibits waiving this right prospectively, I would be with you, because I think I don't see anything that, as a matter of due process, prevents that. But as I dug more into this case, I'm not convinced that the Court of Appeals actually held anything about due process. I think the key language in the Court of Appeals opinion is focused on the text of 42.834.1b,
That's what we looked at.
which talks about, and this is quoted in the Court of Appeals opinion, that a court may not revoke any part of any probated or suspended sentence unless the defendant admits the violation as alleged.
Again, that's the second judge, if not the third, that's just reading the statute back to him. It's tough to argue against that. It's a court. That's the most.
Unless the evidence produced at the hearing establishes the violation. Neither of those things is reached by a waiver, a prospective waiver, at least, because without a prospective waiver doesn't admit specific allegations. It simply dispenses with a hearing. And if you dispense with a hearing, then the thing that the statute says has to happen before the court can revoke hasn't happened. Why isn't a better way to read the Court of Appeals opinion simply to conclude they said this statute imposes a duty on the court. The things that the court has to have before it can act haven't happened, and therefore the court was without power to act, such that waiver never even arises.
Chief Justice, I appreciate the question. How I'd answer that is, and again, getting
It's devastating in my case.
to some of the points that are being brought up here, again, these are rights that the defendant has. And he has the ability to go through a process and give up those rights.
It has nothing to do with
Now,
it.
this particular program was specifically, our sentencing option waiver was
I almost feel bad
designed
for him.
on a specific
I don't,
condition
but
that they
I'll
would
just-
complete the program, complete treatment. Again, serving the interest because, as the court knows from the record, this particular defendant had a number of opportunities. This was kind of the
So
last-
counsel, I think where we're sort of ships passing on the discussion is that you're still holding on to the idea that these are, and you might be right, I don't know, but that these are rights that the defendant holds. And I think there's no doubt that there are any number of rights that the defendant holds. And I would agree, generally speaking, that those are rights that can be given up if given up voluntarily, knowing, and intelligent, and all the other standards that we have for that. That seems to be a separate question of whether anything that the defendant gives up can erase obligations a trial court might have imposed by the General Assembly before X, Y, and Z can happen with probation. You know, that's where I think there are parallel paths that don't always intersect. Sometimes they do intersect. You know, if a defendant wants to give up a right to appeal or a right to appear or something, and there's no obligation on the trial court to hold a hearing or to have some other kind of process, can you try to grapple with what might be a parallel track and how that plays out?
Actually, I just realized I want to show you one thing real quick. I'm going to show you the Court of Appeals decision. Or not the whole thing, just a part of it. So that you can see what the judges are talking about. This is the opinion. Let me see, is the relevant part here. Yeah, right here. Yeah, this is the conclusion here. In fact, the statute specifically provides that a trial court may not revoke a probated or suspended sentence unless the due process safeguards incorporated into the statute are satisfied. The trial court was not authorized to revoke any portion of Greathouse's probated or suspended sentence without either A, receiving an admission, or B, receiving sufficient evidence at a hearing. Oh, hey, Mary. All good. Thank you for coming. So that is why the court they're looking at that and saying, oh, the court kind of put it in terms of due process, but really they're just quoting the statute and saying you have to follow the statute. Okay, go back to my thing here. There we go. Sufficient, yeah.
Hopefully, I'm getting on that track, but I would say this is parallel to what we would do in a number of sentences with a future Fourth Amendment waiver.
But is there, in those situations, is there a statute that says before this Fourth Amendment waiver happens, the trial court must hold a hearing and must make these findings?
It would just be during the sentencing conversation that judge would have with the defendant. It would be no different. There could be a sentencing option waiver where a defendant is pleading guilty on a case and also opting into the sentencing option waiver where they would have a conversation.
Totally get that, 100%. The challenge here is with a Fourth
Again, I don't want to beat up on this guy too badly because he was like they did he has been bamboozled, 100%. But they're just trying. It feels like they're trying to explain the concept again at this point.
Sentencing option waiver where they would have a
Totally get that, 100%. The challenge here is with a Fourth Amendment waiver, your probation officer can show up at your house and say, hey, you've got this waiver, please let me in and come look around. And that's sort of self-executing. The problem here is the probation revocation statute 34.1 says a trial court shall not revoke unless one of two conditions precedent has been satisfied. The defendant's waiver of a hearing doesn't satisfy either of those statutory conditions precedent as the Court of Appeals interpreted the statute, if I'm reading the opinion correctly. And so it may be one of those cases where even though the waiver was effective, it still doesn't allow the trial court to revoke because the trial court has its own independent statutory obligations under 34.1.
Yep.
Now, if instead of a prospective waiver of a hearing, you had a prospective waiver of the right to appeal a future probation revocation, that might actually be effective regardless of the trial court's obligations under 34.1. But if it's just the prospective hearing, I don't know that the defendant saying I don't need a hearing empowers the trial court to do something that the statute says you can't do until you've done these things. Because it's not a right of a defendant, it's an independent statutorily imposed obligation of the trial court.
The only thing that I would say to that is that I think those issues could potentially also be present in Zedner and Ricketts. These weren't concerns that Justice Alito or Justice White had in those cases. Justice Alito was specifically concerned about, he actually said, if this is a right that only the individual in this case holds, he could waive his speedy trial right. The concern there is the future impact, not necessarily, I guess, a separation of powers issue between the trial court and the prosecuting office and the defendant. But I think that was the major concern from a Supreme Court level is, are there third order effects in this waiver? That's not the case here. And then the additional question is, does it negatively impact the public interest, which this sentencing option waiver helps the public interest because we're stopping overdoses, getting people into industry.
What evidence is there that this probationer's waiver was knowing and voluntary?
I love his accent. Every time he speaks.
It's within the signed orders.
Just the document? Is there any evidence other than the document itself?
I would say, again, that he's gone through multiple steps. He's pled guilty to an original case where all of these conversations have happened about what his rights are.
You just put a piece of paper in front of him and told him to sign it? Obviously, that's good enough. I can think of no examples where that would be a problem.
What probation is, that initial time going on to probation.
Specifically with regard to this question of the waiver or alleged waiver of the hearing, what evidence in this record is there that that was knowingly and voluntarily done as opposed to somebody just stuck a paper in front of him and he signed it?
How do we know it was knowing and voluntary? They didn't just stick a piece of paper in front of him and he signed it. No subtweets here.
With the course
done of the hearing, what evidence in this record is there that that was knowingly and voluntarily done as opposed to somebody just stuck a paper in front of him and he signed it?
With the court's permission, I could show the paperwork, the rights waiver.
But I'm starting to sound like a judge? I will never be allowed to be a judge. I would love to be a judge. But I have to delete a lot of content off the internet before I even have a chance of being a judge. I can just imagine I'm going to be going before the Senate someday and be like, is this a video of you calling a prosecutor a chicken fucker? And we'll be like, yes, and I stand by that. But which I do. But like that, I'm never going to get it confirmed. I mean, that's never going to happen.
It's specifically signed by this individual. It's gone over by.
I'm
the
happy to
probation.
see the paperwork. I'm just asking whether there's any evidence other than that piece of paper.
Just the paperwork, and that serves the public interest of, hey, can we
Just the paperwork that the probation officer.
get this individual into treatment quickly? This is an individual who, again, from
To be clear, no probation officer in the state of Georgia has ever said anything incorrect. I want to be very clear about that.
the record has gone through this process a number of times, has had the opportunity to be in treatment
And he'd
programs.
executed a number of waivers before. This was not the first waiver.
Yeah,
He
yes, ma'am.
acknowledged 3 of those, correct? And there was actually an affidavit by the officer attesting that this had been gone over, correct?
This is Sean LaGrua. You may remember her from her career as a prosecutor in Fulton County.
Correct, not
No further
just
comment?
his signature.
That is
Actually,
correct.
an affidavit from the officer.
Yes, Justice.
But none of those.
She was the only judge to, or justice to dissent in the opinion in this case. Just so you know, it was 8-1. The defense won because fucking obviously. But yeah, she was the lone dissent. She was the lone dissent on a few other cases I've looked at.
None of those things that Justice LaGrua mentioned go to proving that he voluntarily, intentionally.
Oh, actually, if you guys remember, how many defense attorneys? I don't know. The Nancy Grace case. Remember the one that I did a stream on it like a couple months ago. LaGrua was the one that actually took over for Nancy Grace in the case where Nancy Grace broke into the defendant's house to do a CNN taped special interview. And LaGrua is the one that didn't, I believe, I could be wrong about this. McBurney was involved too, but I think it was LaGrua that didn't hire the arson expert, even though repeatedly represented to the court that they had. I could be wrong about that. But I know she was involved in that prosecution. Carr, I think was the guy's name.
Knowingly
Oh, hey, Kels.
understood everything in the waiver, although circumstances would suggest maybe he did, but there's nothing empirical in the record.
Well, that would also be true, for example, under
This is the
42H.
self-snitching part. Earlier when I said these 2 minutes are the part that you can inject straight into my veins, I was talking about this part. I was just too early. Think about the context of what he's being asked and what his answer is. The question is, okay, there's a signature. How do we know it's legitimate? It's just a piece of paper. We have nothing but the piece of paper to rely on. Is there something else?
34.
So
In the
think
record.
about
Well,
the answer.
that would also be true, for example,
Let
under
me go back a little further.
Go to proving that he none of those things that Justice LaGrua mentioned go to proving that he voluntarily, intentionally, knowingly understood
this
everything
part.
in the waiver, although circumstances would suggest maybe he did, but there's nothing empirical in the record.
Well, that would also be true, for example, under
That would also be true. So he's going to name a bunch of other circumstances in which all we rely on is a signature on a piece of paper and nothing else. So this answer is going to call into question all of the things that he's about to say. And plus, I don't think he realizes what he's saying because it's off the cuff, but still.
42.834.1b, if someone just signed paperwork of a consent order, that would again be the only evidence. Sometimes individuals can sign a consent order pro se. They can sign a consent order just meeting their public defender that day, and that may be the only record that we have is that they understood the rights that they were given up to a hearing through that consent order. So it'd be similar to what happens in a number of
It would
probation
be.
cases that we have in the state.
But counsel, I mean, is there any other situation
I love it. He told the truth. He's not wrong.
where we have a defendant who is sent to jail based on some sort of waiver, and the court, either us or the U.S. Supreme Court, does not require that there be a record that the waiver was knowing and voluntary? I mean, a plea, for instance. Could a defendant sign a piece of paper at the bond hearing outside of the presence of the court saying, I plead to this charge, and be sent to prison? I mean, we don't allow that. So why would we allow that here?
Because I think if this court looked at the persuasive authority in the Seventh Circuit with that Domke case, specifically the individual in that case was giving up the right to challenge the breathalyzer test in the DUI sentencing regime. So he...
Yeah, I will say, Matthew says, I like how conversational, down to earth, the justices here communicate. I've always been really impressed with the Georgia Supreme Court, even though there's, one or two I dislike or disagree with. Yeah, I think very highly of the court as a whole.
He popped hot on a breathalyzer test. He'd given up his right to a hearing, given up his right to challenge that, and to be given notice of a hearing. And the Seventh Circuit looked at that case and said that is fine from a constitutional standpoint because it fits in with what Zedner and Ricketts is concerned about. Is this knowing involuntary? Is it intelligent that you're giving up this right to have some sort of benefit to get into a specific program? And the same thing with Zedner. It fits within the public interest in not negatively impacting third parties by giving up that right.
Two practical questions. If the officer's affidavit is false, he can be prosecuted if you can prove it, correct?
That is correct.
What's the incentive for the district attorney or solicitor's office or U.S. attorney's office, though we're not here on a federal case, to be lenient or provide a deal for someone in exchange for something if they can't?
Specifically, if a probation officer had...
I disagree with the premise of the question. She's saying, if they can't do this, why would they be lenient? You can do this if you just do it differently. There would be a way to get to this result very easily and very quickly if you just do it in a slightly different way. So we're not really talking about you can't ever offer leniency now. I mean, it's just a strange question.
No.
Okay.
Yeah, I really like the red hair. I can't think of her name, but she's awesome.
Or you've answered the first question. The second question is, what's the motivation for the prosecutor's office to be lenient or give a deal to someone if they can't waive their rights to something else?
I would say
Well, having a soul would be one.
There wouldn't be an incentive for prosecutors to be lenient. I think when you look at the record of this defendant, he was at the end of the rope. We'd have to look for sentences at a revocation hearing to ensure that this defendant went to prison. And again, I come back to that public interest sort of Damocles argument. We know there are really only two situations.
Well, but counsel, respectfully, there are other public interests that have to be weighed too, and there are public interest in having a record that people are giving up their rights the right way and according to a process, and that's the countervailing public interest that the General Assembly set forth in that statutory scheme for trial court. So, though I think you're, giving some...
I will say, in general, I'm sure many of you know this, but public policy arguments are going to be significantly less convincing when there's a statute directly on point. And that's what she's getting at here. There is a public policy. In fact, they don't argue this here, but I did because I'm great. The most recent amendment of this statute, there is some text in the statute, I believe, or in, the preface to the statute that says they're specifically making these obligations as specific as possible because they want these steps to be followed because there's a loss of liberty at stake. And so, obviously you need to follow the statute in any case, but here the Assembly could not have been more specific that you have to follow these rules.
Some really good examples of why you would want to be able to waive the right. It's not, those rights don't, and those incentives don't exist in a vacuum.
That's correct, and that's what Justice Alito is talking about in the opinion in Zedner. And I think what the sentencing option waiver in this case does fits within Zedner. It doesn't impact third parties. It only impacts the person who is considering the sentencing option waiver. They could very well say, I'm not going to sign this. I want to go through the normal process. And it serves the public interest again by making sure that person has incentive to complete treatment.
Do the treatment or you go to prison.
Thank you for your time this morning. Really appreciate your questions this morning. Thank you.
Thank you, counsel.
He did well, to be fair. As well as could be expected.
A minute
I
left
disagree
for
with
rebuttal
everything
if you want to use it.
But
Mr. Cathy.
given that the discussion was...
Mr. Chief Justice, honorable members of the court, thank you for having me up here today, down here from Northwest Georgia. I'm here obviously on behalf of Mr. Greathouse. Justice McMillan, I would like to fill in just a little bit about how this process happens. You
I
seem
love his
curious
accent,
about that. In our circuit, it's common when a probationer is arrested on a violation, they go to our local jail. And sometime after they're arrested, but prior to there being a petition filed, they'll get a visit from a probation officer. At that point, I don't have a problem with this at all. Usually, that involves the offer of some leniency in the sentencing on their probation violation, 30 days, some sort of rehab. Again, I don't have a problem.
I do. Why is the probation officer offering leniency? That's not even up to them. Okay, I'm going to shut up.
With that construct at all. What Mr. Greathouse is dealing with is a situation where he was visited at the jail during that time frame, before a petition is filed, before a public defender is able to talk to him about his pending case, and he was offered this deal, and that deal was that he would submit to a full revocation of his probation, but that the full revocation would be suspended upon the requirement that he complete a rehabilitation program. And it further stated that if he didn't complete the program or if he violated probation, he waived notice to right in a hearing. This is a scheme set up to essentially fast track a future violation or a future allegation of violation without giving the accused an opportunity to address that with the court, which, I think your honors have said several times this morning is an obligation upon the court by statute, and I believe that's true. Of course, we were asked to look into whether or not this was waivable, and that's what I'm prepared to discuss this morning.
Yeah, see, again, this lawyer is also prepared to discuss waiver and whether you're allowed to waive stuff, which is kind of fun.
To the extent that this is a right that the defendant can waive, it cannot possibly be waived in this scenario. And the issue with that waiver is in the timing of the waiver. In every other case, with the exception of the Fourth Amendment cases.
So,
that were
counsel, I'm going to
discussed-
ask you the same
Yes.
question I asked your friend across the way, and that is, at the cert stage, the briefing certainly framed up the Court of Appeals opinion as deciding as a matter of due process that this prospective waiver was invalid. I don't actually see that holding in the Court of Appeals opinion. What I see in the Court of Appeals opinion is a statutory holding about the trial court's power. And 34.1 says that the trial court may not revoke any part of the sentence until one of these two things has happened. And then the Court of
I think this is like the fifth time they've read the statute. It's kind of
Appeals goes on to talk about that statutory requirement and then concludes that the trial court was not authorized to revoke under that provision. If that's a statutory holding, do we even need to talk about due process?
No. Say no.
I think if we're prepared to say that that's a statutory obligation upon the court, then no. I mean, I think that we have a waiver in the statute that says an admission is essentially a waiver, but it's done at the time. Just as an aside, the court did at least touch on the due process concerns there. But of course, and
really the only thing the court said about due process was that due process affords a right to a notice in a hearing,
Yes.
which if the Court of Appeals did then go on to hold that therefore this waiver is invalid, there's no reasoning about why a waiver would be invalid as a matter of due process, because the only thing they say about due process is you do have a right to a notice in a hearing. Obviously, a right has to exist for a waiver to be relevant. Because if the right to notice in a hearing didn't exist, then we wouldn't be talking about waiver at all, because there'd be nothing to waive. But I just don't see any actual holding on due process grounds here. It seems purely statutory.
Oh, fun fact, Judge Dillard, who some of you may recognize from Twitter, was one of the three judges on the appellate panel.
I think that's correct, and I think that you can, to the extent that we're talking about a waiver, invalidate that waiver by enforcing the statute upon the court.
He's also kind of, I don't think he's completely getting the point either, which again, like the judge, they were told to focus on the due process thing. But really the answer should be yes. There are statutory obligations, end of argument, end of story.
Would it be that the waiver is invalid, or just that it has limited scope.
It's
Meaning like,
not what we
assuming that the waiver is voluntary, sure, you waive. There's nothing in the statute that says that there can be no waiver, but the waiver just can't cross the barrier into obviating a statutory requirement.
Well, it's my position that waiver's impossible.
It might be futile. I mean, it's not, would you agree that there's nothing in the code that says you shall not obtain a waiver under these circumstances?
Absolutely agree with that. There's
So,
not an express
it's not an-
provision. I don't
not
think
an
we need to get
anti-waiver
there.
provision.
I don't think we need to have that provision for it not to be a possibility in this case, and that has to do with the timing of it. A waiver, in order to be valid, has to be knowing, and in order to be knowing, the accused has to know the factual nature of the allegations against him. And when those factual allegations don't exist at the time the waiver's made, how can he make a waiver? That waiver can only come after the commission of the criminal behavior. And if you look at these cases, if you look at Ricketts, if you look at well, Zedner wasn't necessarily on point with that, but they all come after the criminal behavior.
This is a little bit, counsel, a little bit different kind of waiver, though. I mean, it's sort of like, I know if I mess up,
Right.
we're going straight to go.
But who's to say if I mess up?
Your point is after you enter this waiver, if they say we're going to revoke because you chewed bubble gum, that in theory, if the waiver is applicable, then you're not allowed to say, well, wait a minute, that's not a violation of my probation.
Well, I mean, the
Who would ever revoke somebody for a condition not contained in the sentence? That would never happen.
situation here, he was forbidden from leaving his rehabilitation facility. And it's not in dispute that he left his rehabilitation facility. It's in dispute as to why. And he says that he was not getting his proper medication for his diabetes, which was twofold. It was a medical necessity that he leave, and that also clouded his judgment to some degree. And he never was given an opportunity to at least go to the court and say, yes, I did this, but. And I think that's the issue here. That's the due process concern.
But we allow all sorts of rights to be waived so long as the waiver is knowing and intelligent and voluntary. I mean, the fact that this is an important right and he's in a tough spot having waived it, that's true for all sorts of rights that get waived.
Absolutely.
Yeah, I think that's where the argument's kind of going astray. You probably can waive the right, but we should be leaning into the statutory application.
Somebody who does a prospective Fourth Amendment waiver while on probation often winds up in a tough spot.
Yes, but I would distinguish it from the Fourth Amendment waivers. And what if we had a Fourth Amendment waiver where if you get caught with cocaine in your home, you go directly to prison? Everybody who gets caught with cocaine in their home after they receive after signing a Fourth Amendment waiver has a right to a trial. They have all the same rights that any other criminal litigant has. And we don't have Fourth Amendment waivers like that. All we have is you can say, yes, you can come search my home anytime. And if we don't find anything, then there's not an issue. But if we find something, you still have the same rights as anybody else. To analogize this with the Ricketts case just a little bit, the Ricketts matter, that young man waived his double jeopardy rights. And when he failed to testify, he didn't go to death row. He went back to trial. And if he went straight to death row, that would be like what we did to
We need to take a look at that. That sounds wild.
Mr. Greathouse here. Is he violated based on some lower standard. In fact, actually, the document that he signed lowers the standard for that future violation from preponderance of the evidence to that of probable cause. And based on that, we're going to issue the worst punishment for this that we're authorized to issue, which is a full revocation. And that would be how I would distinguish it from those Fourth Amendment waivers. And those Fourth Amendment waivers, I think you would also have to get
Which
into.
they could have done before they gave him an opportunity to go to the treatment program, correct? They could have had a hearing and revoked his entire probation instead of letting him go to the treatment program, correct?
Initially in the November proceeding? Yes, they could have. And for whatever reason, the state chose that bargain as well. They chose not to revoke his probation.
They could have just asked for an appeal waiver, and so long as that was knowing and voluntary, you wouldn't get to be here today.
Yep.
Right?
Like I said, there are plenty of ways to do this.
I believe they could have asked for an appeal waiver if he were to admit to the conduct, but I don't think he could have waived a right to an appeal before there's an allegation of criminal conduct. I mean, how could that waiver be knowing? I mean, I think that's the central issue here, is that he can't know what he's waiving if he doesn't know what he's done.
But he
Is there
can
an
know he's
allegation
giving.
he didn't understand the waiver he signed and that the officer lied on his affidavit
Well,
about the conditions?
And to touch on that briefly, I think you were asked if the officer had attested that he was, read this waiver and understood these things. And that affidavit is right here. That affidavit only spells out the allegations against him. That does not contain any language from the probation officer that he read him those rights. Now, there's a waiver of rights at the back of that consent order, but that's in regard to that current pending case. That's not in regard to any future case, and it doesn't have any language that would indicate it is.
But Counselor, couldn't he waive not knowing what the future might hold just because he doesn't want to deal with the consequences of what may come if he admits?
I think the key word there is knowing. I mean, you said, can he waive not knowing?
He can waive knowingly giving up the right to contest whatever might be a violation that may come up.
But in order for it to be knowing, as this court has held.
Counselor, it sounds like you're saying that if you don't know the future, then you can't waive, and that's not the standard. If you know and understand what process and procedure is afforded to you and what you would be giving up, as long as the other circumstances are met, we don't have to do a play-by-play of what the future would hold so that you know what would be said at the hearing that you're giving up.
But I think you have to know what the past has held. I mean, that's clear from the Green case. You have to know the factual basis of the charge, you have to know the potential punishments, you have to know the rights you're waiving and the nature of the charge and the facts surrounding that. All of these waivers, anytime this court has permitted this, with the exception of the
Why didn't your client know that here where he has gone through this process many times?
That's correct. You don't need to know the future to waive your rights about the future. That is kind of what a waiver is. Yeah, I think his argument's kind of going astray here, but he's already won, to be honest. So
And waived this hearing many times.
Because
He knows exactly what's going
It was
on.
5 months before he left before he left the rehabilitation program, and he didn't know that he was not going to receive his diabetic medication.
No, that's
while
not
he
what
was
a
there.
knowing waiver is. That's not what a knowing waiver. A waiver is as to process and availability. It's not as to every possible, combination and permutation of facts that could happen in the future. Otherwise, you could never waive anything.
yeah, exactly.
We have no.
A Fourth Amendment waiver can be knowing without knowing when and who's going to come and want to look through your house.
Right.
So if you're charged with armed robbery as a party to the crime, and the state says, okay, we're going to reduce this mandatory minimum 10-year prison sentence, 10 years to the door, no parole. We're willing to reduce it to robbery and a 5-year probated sentence if your client agrees not to appeal. He's giving up his right to appeal, even though he could go to trial, and as, who knows, party to the crime, he could be acquitted, correct? So he can't do that, because he doesn't know the future.
No, I think he can do that because he knows what he did. And he's taking that bargain in light of
So
what
your
he did.
client did not know he left the rehabilitation center?
At the time he made this waiver, no, he did not, because it was 5 months before.
Well, if you had gone to, you don't know what would have happened if you had gone to trial on your armed robbery case. You were a party to the crime. It might have been reduced. The jury might have acquitted you, found you guilty of robbery, found you guilty of disorderly conduct. You can't know any of that because it's in the future, correct?
The difference between where you are, and I think, and where Justice LaGrua is you do know all of the nature of the charges in that case. What you're suggesting is, in that world, you couldn't waive the appeal of your probation revocation. So you take the deal, you get the reduced robbery sentence. What you're suggesting is you couldn't waive the appeal of your probation revocation that has yet to materialize.
Exactly.
But here you know that the condition that facilitates your revocation is leaving the rehabilitation facility, correct?
Yes, but I mean, are we saying that there's not ever a valid reason that someone might
But that's
leave?
not why we're here. We're not here to litigate the facts of whether, this was anticipated. We're trying to figure out whether this is waivable at all.
And I understand that, and that's why I'm saying that it's not, is because he doesn't know what circumstances might exist whenever he potentially
That's
leaves.
specific to his case.
I think that's specific to any case where such a waiver would be made.
Well, then you're making an argument that there's no such thing as waiver in the law, and I don't think that's going to be your
I
best
don't think I'm
argument.
being quite that broad, respectfully, Justice Warren. I think I'm talking about cases where waivers are made prior to the
In
allegation of
this,
criminal
in this
conduct.
case, in this case, we have all agreed that he left.
Correct.
But as I understand the state's position, even if he asserted that he didn't leave, that somebody was lying, somebody says, well, he wasn't there, and he says, no, I would like to be heard because I in fact did not leave, he would not have been able to litigate that. Is that do you agree that that's where the state is?
I agree with that, absolutely.
And to me, I understand that that's not your facts, but to me, that's the sort of the more problematic rendition of what you're describing is I'm waiving the ability to challenge the thing. I know you're saying, sort of guilty with a good explanation, right?
Mm-hmm.
But those are a little bit different because we're all saying, well, you did violate the terms, and then we're now litigating over why you did it.
Mm-hmm.
Your reading, and I think it's the state's reading too, and mine, is that their position is that it even happened is something that can't be, that's something that hasn't happened at the time you enter into a waiver cannot be contested in a future setting.
I think that's exactly the case. I mean, if he stayed in his facility and the probation officer just wanted him off his docket or off his rolls, he could just submit this affidavit to a judge, have this order signed, and he'd be off to prison and he'd not be his problem anymore with absolutely zero appellate recourse. And I think there's a number of other problems with this as well. If I could just briefly go into some of the policy considerations here, which were touched on earlier. Clearly, there is a policy to expedite these proceedings. However, there's also a public policy in favor of treating people fairly and due process for litigants. Each of those policies is captured in the statute that directs us, the state's framework that's been promulgated. Each of those policies is incorporated therein. Probation hearing is necessarily an abbreviated hearing. We enjoy a lower standard of guilt. We don't have a jury. We don't have indictments. At the same time, we have simple rights to notice and a hearing and an opportunity to cross-examine, and those rights were not afforded to Mr. Greathouse when he was...
Wait, you have a right to cross-examine in probation revocation hearings? Huh.
When he was revoked in this matter.
That's interesting.
Because I think it was impossible for this to have been a knowing waiver, for the main reason that it was prior to any allegation that he had violated his probation and the public policy concerns demand, I think the state, that we have to affirm the decision of the Court of Appeals. If there's no other questions, I thank you for your time.
Thank you, counsel.
Okay, that's the end
Floor, I believe
of...
you have a minute left.
Wait, does he go?
Thank you.
Okay, no, I don't think so.
Thank you, counsel. Well argued on both sides. We will get you an opinion within...
So they just released the opinion this week? Last week? Last week. Let me pull it up on my...
The time required by the...
No, not you. This one? This one. I'm not going to read the dissent. It's by Ellington. The state challenges the Court of Appeals decision vacating the trial court's revocation of appellee Greathouse's probation. Put simply, the plain language of OCGA 42834.1b controls this case. So again, it's pretty simple holding. It limits the trial court's authority to revoke probation without the occurrence of at least one of two conditions. Because neither of those conditions occurred in this case, the Court of Appeals correctly vacated the revocation of Greathouse's probation. So again, no mention of due process here because it's strictly statutory. In November of 23, Greathouse was on probation when he was arrested following an allegation that he violated his probation. Greathouse entered into a consent order of revocation, which revoked probation, but allowed the balance of his sentence to be suspended upon his successful completion of a 9-month inpatient drug treatment program. The consent order included provisions that waived his rights to the filing of a written probation revocation petition, to a revocation hearing, and to have counsel appointed for the instant revocation. You actually don't have a right to counsel in probation revocation hearings. That's interesting that they wrote that way. Yeah, there is no right to counsel in probation revocation. It does have to be effective assistance if you have counsel, though. Okay. But the consent order also included provision that prospectively waived any constitutional or statutory right to a probation revocation hearing that Greathouse might have for any unknown future alleged probation violation. That's the waiver there. On April 3rd, a community supervision officer submitted an affidavit to the trial court alleging that Greathouse left the inpatient treatment facility prior to the completion of the program. And on the same day, the trial court issued another arrest order authorizing law enforcement to apprehend Greathouse and transfer him into the custody of the DOC to serve the balance of his probation in custody. Greathouse filed a motion to vacate the arrest order and to modify the sentence on revocation of probation, and the court ordered said motion to come on for hearing and ordered its arrest order to be suspended until the motion was heard. The mayor says, appreciate the channels I follow. This year is my first Supreme Court anything. It's great to see how it all really works and how educational it is. First Supreme Court anything. I didn't hear more about that. On the 25th, the trial court held a hearing on the enforcement of the consent order, during which Greathouse's counsel asked that the consent order be vacated because Greathouse entered into it without counsel, and asked the trial court hear Greathouse's argument on the merits. During the April 25th hearing, the state did not present any evidence supporting the revocation of probation, either in the form of the sworn affidavit or the testimony of the officer alleging the violation. Instead, the state explained that if Greathouse wants to have a hearing and a petition filed, then he will sit here and his parole date will be even later than it would have been if the consent order he signed was to be enforced. At the conclusion of the hearing, the trial court denied the motion. On appeal, the Court of Appeals vacated the trial court's order. Specifically, the Court of Appeals held that the trial court was not authorized to revoke any part of Greathouse's probated or suspended sentence without Greathouse admitting the violation as alleged or without a revocation hearing according to the statute. So again, the court saying we're talking about the obligations of the court here. This has nothing to do with whether the defendant did or did not waive something, because we're talking about the obligations of the court. And like whether the defendant waived something doesn't really have much to do with the court's obligations. The Court of Appeals explained that the statute did not provide for a waiver of right to a future hearing, but rather it explicitly prohibited a court from revoking a probated or suspended sentence unless the due process safeguards incorporated into the statute are satisfied. The state sought review, arguing that many rights in criminal proceedings may be waived, including the right to a probation revocation hearing, and that due process does not prohibit a probationer from opting into an alternative dispute resolution to avoid future ramifications. At the cert stage, the party suggested that the Court of Appeals decided that due process prohibited a waiver to a probation revocation hearing. We granted review to consider whether a defendant may prospectively waive constitutional or statutory rights to a probation revocation hearing in the event of a future violation of probation. However, upon further review and consideration of the Court of Appeals opinion, it is now clear to us that that question is not presented by the Court of Appeals opinion. The Court of Appeals did not make a ruling regarding waiver or due process, but rather issued a decision explaining the statute's limitation on a trial court's authority to revoke probation. We now conclude that 34.1b limits the trial court's authority to revoke a probated or suspended sentence without first either receiving the probationer's admission to violation or conducting a hearing where the evidence establishes the violation by a preponderance of the evidence. And a defendant's purported waiver of any such hearing, such as the purported waiver of a hearing included in the consent order here, will not alleviate the trial court's obligation to hold such a hearing if the defendant has not admitted to the violation. So again, it's not even about the waiver at all. The court's got to do something, irrespective of the waiver. I'm going to go through the whole thing. To begin, we recall the well-settled principles that guide our consideration of a statute's proper construction. In interpreting statutes, we presume that the General Assembly meant what it said and said what it meant. They say that a lot. We afford the statutory text is plain in ordinary meaning, view it in the context in which it appears, and read it in its most natural and reasonable way. For context, we may look to the other provisions of the same statute, the structure and history of the whole statute, and the other law, constitutional, statutory, and common alike that forms the legal background of the provision in question. When, as here, the statutory text is clear and unambiguous, our interpretive task begins and ends with the text itself. Under 34.1b, a court may not revoke any part of any probated or suspended sentence unless the defendant admits the violation as alleged, or unless the evidence produced at the revocation hearing establishes by preponderance of the evidence the violations alleged. On appeal, the state does not cite 234.1b, but rather the state argues that the absence of an express anti-waiver provision means that Greathouse could validly waive his right to a probation revocation hearing, because if the General Assembly had intended to prohibit a probationary's ability to waive his right to a hearing, it would have included an express anti-provision in the statute. Hey, Weppy, what if there are no violations alleged? I don't know, Kat. That would never happen. It is true that generally, if there's no constitutional, statutory, or public policy prohibition against a waiver, an accused may waive any right. The state, however, overlooks the express language from subsection B that restricts the court's authority to revoke probation without the probationer first admitting the allegation or without the court holding a hearing, irrespective of any attempt by the probationer to waive his right to the hearing. That's really the key to this whole holding. I know I've said this a few times. Yeah, this part right here. Yeah. The court's gotta follow the rules. It's not about waiver. The court's got to do what it's got to do. It can't skip out. What if they told you break the law as a condition of probation, but you didn't? That's ridiculous. I do need some emojis. I didn't even like to think about that. Let's see. The dissenting opinion nonetheless contends, that would be LaGrua, that Greathouse was authorized to waive the hearing because of the background legal rule that generally allows defendants to waive rights given to them so long as there is no constitutional, statutory, or public policy prohibition, and the dissenting opinion cites to a number of cases that illustrate that general principle. But those cases are distinguishable because the statutes or constitutional provisions that provided the criminal defendant the right that was waived in those cases did not involve express statutory language that restricted a court's authority to act, as 34.1b does. Here, unlike in those cases, the express statutory language contained in 34.1 that the court may not act unless one of the two preconditions occurred, in the absence of any language expressly permitting waiver of the two requirements, means that Greathouse could not circumvent the trial court's requirement to hold a hearing in the absence of Greathouse's admission to the violation. Yeah, totally. The dissenting opinion contends the trial court satisfied the statute when it held the hearing on April 25th, 2 days after I filed my Muntuk motion, but the state has made no argument in this court and made no argument in the Court of Appeals that the April 25th hearing satisfied the trial court's obligations. And the record suggests that the purpose of that hearing was to address Greathouse's motion to vacate the arrest order and modify the sentence on probation and revocation, not to discuss the merits of the revocation in the first place. Because the statutory text is clear and unambiguous, and there is no contextual reason to suggest the trial court had the authority to revoke probation without one of the two preconditions prescribed in 30.1b having occurred first, our interpretive task begins and ends there. That's really the whole of it. When I was in school, they barely covered anything about the Supreme Court. Yeah, that's true. So for me, it's just been live and learn as I go through life, to actually get to watch and yeah, no, I agree. I really like the Georgia Supreme Court's accessibility. I'll actually show you guys real quick. They put up these, I'll show you their website, so you can see how it works. This one? Okay. So this is the Georgia Supreme Court website. And one of the things I like that they do is if you go to this oral argument part, you can go to the case announcements, and you can, so there's, most recent one was November 4th. Sorry, I only have one monitor because I just moved and I broke my monitor, my main monitor, so I have like my little one. So I'm trying to work around, work with everything on one little monitor. Okay, so these usually come out like a month or so before, but they will give you a brief summary of the cases that they're going to hear on video. Let's give you a little bit of the procedural history, the arguments that are being made by both sides, And then they actually give you the links to the briefs down here at the bottom. So you can actually just go and directly pull up the briefs for both sides if you actually want to read through the full documents themselves, which I think is really cool. I really like that they do that. And then also, you can go to opinions, and they have, let me put this a little bigger. So they put out their opinions in groups, obviously, dates here, and you can click summaries of noteworthy opinions, and if there's anything particularly interesting, they did do it here because there's only one opinion, but for instance here, if there's anything that's, wow, I'm striking out on good examples. This one has to have one. Okay, so here's one. They also have summaries of the opinions that were noteworthy in some way, that involve overruling convictions or changes in the law. They'll identify these the parties. For instance, in this case, you'll see that this was a Gwinnett County case. And so even if you can't understand the full opinion, you can go through and look at the summaries. So what was that one? That was Smith versus State. So you can go here, and then this will be the full opinion. Yeah. Man, I'm gonna get demonetized. Let me see. Yeah, I like doing streams with Kat. Although I was getting like all that the Tyrone, the last one we did with the Tyrone Blackburn debunking by Takapina, I was getting like worn out by the end of that stream. It was like 4 hours of nonsense, and I'm good for like 2-3 hours of nonsense, but man, I was getting tuckered out. That was a lot. That was just a lot. That was. Blackburn, he really went in on that one. Let me see. Oh, no, monitor. Yeah. Let me see. Where's this New York thing? Here we go. The 15 minutes? Okay.
The decision below is irreconcilable.
I like this. 15 minutes, I can do this. I think I'm probably going to be done after this because I have some work I got to do. And also I need to eat at some point. But I'm always here for, yeah. Kat is yeah. I mean, Kat, like, all the YSL streamers are just, I mean, like, some of the days were fun, but, like, there were days in YSL where just 8 hours of, like, borderline unintelligible jail interviews, jail calls. I can't. I wish I could, but I just don't have it in me. All right. 8 hours of Dom Witt. Seriously. Unleashing Taco Pina. I really want to do with streams where I just troll the law and crime chat. Because it looks really fun. I mean, it is fun because I do it all the time, but I should make like a stream out of it. All right, here we go. First of all, we get this. Oh, let me see if I can make this fit better. There we go. That looks better. All right.
Irreconcilable with the Supreme Court's decision in Press Enterprise 2. The decision below is irreconcilable with the New York Court of Appeals decision in Herald v. Weissenberg. And the decision below is irreconcilable with two decisions from this very court, Dover, City of Schenectady, and Moshe v. Hanley. Start with the First Amendment.
That's some high quality production value, I have to say.
Just last February, the Court of Appeals held, quote, the public is vested with an inherent right to know. And that official secrecy is anathematic to our form of government.
Whoa.
NYCLU versus City of Rochester.
Anathematic. I didn't even know that was like a form of the word. That was such a big word, it broke my YouTube.
Respondent agrees
There we go.
that Press Enterprise 2 controls the outcome of the First Amendment claim here. Press Enterprise established a two-part test for determining whether a particular restriction on public access violates the First Amendment. The first part of the test examines not only whether the public has historically enjoyed the access sought, but whether they currently enjoy it in comparable proceedings throughout the United States. Emerging traditions count as much as historical ones. That's according to El Vocero DPR versus Puerto Rico, a Supreme Court decision from 1993. There, the court rejected an argument that because probable cause hearings in Puerto Rico were historically closed, that members of the press did not have a First Amendment right to access preliminary hearings.
Let's talk about your first prong, where you discussed that under the issue of whether the First Amendment
Man, my one monitor is not holding up well.
provides you the right to appear and be present at these disciplinary hearings. The case you cite does have a two-part test, and the one part is that whether these proceedings have been historically open to the public. And the answer here is generally no, in that these type of proceedings for which you're seeking to be present at have not been. They have generally been confidential.
Man,
Would that be accurate?
Yes and no. 15 states and the District of Columbia require public police disciplinary hearings by law. 13 states allow but do not require public hearings. 15 states allow after the fact access to the hearings if the officer is found guilty by allowing access to the hearing record. And Your Honors, I did my homework. I have a list. It's also published on my website yesterday, freelancenews.org. I have a list, a state-by-state list of the laws in each state and regulations and practices as they relate to police disciplinary hearings across the nation.
The question then that perhaps it's a matter for the legislature as opposed to the court?
Negative, Your Honor, because first of all, the legislature has already spoken on this, and they have not prohibited public access. But greater than that,
he did kind of shoot himself in the foot by opening with the Puerto Rico example, because he gave an example of a situation in which public access was not allowed, even though generally nationwide, apparently access was allowed. So that seems to cut against his argument.
Are you talking about the repeal of 50A or?
Yes, Justice Powers, that's correct. But even
that pertained to records that would be now accessible where they weren't before, correct? Isn't the issue here slightly different where you're asking to be able to be present at disciplinary proceedings?
That's correct, Your Honor. But this is why the Supreme Court's decision in El Vocero DPR versus Puerto Rico is so important to the correct analysis of the first prong of the press enterprise test. The first prong of the press enterprise test is not just solely limited to history in the locality where the challenge is made or where the hearing is held.
So that's what you're saying. Let me just move you along here a little bit because you have limited time. You're basically saying, don't look at the first prong in terms of just history. You have to look at it across the United States and whether or not right now in present day, incomparable type.
That's correct, Justice Reynolds Fitzgerald. Emerging traditions under the Supreme Court's decision in El Vocero, emerging traditions are as important as historical practices.
Okay, so you got to get to the next prong.
So the next prong is a very simple one, and it's whether the public access would facilitate, would serve the public interest. And people greater than me explain that a lot better than I could. The Second Circuit did in New York Civil Liberties Union versus this MTA. And this is a decision that I cite repeatedly in my brief. And they say that public access to administrative disciplinary type hearings, like a trial, both involves fact-finding and legal decision-making, and the hearing is subject to the same dangers, whether willful or accidental, as a trial. Dangers that can be reduced significantly by the kind of public scrutiny that enhances the quality and safeguards the integrity of the process. That's just one reason. The second reason is individuals confront the power of their government to judge and penalize their actions like a trial. And that's the second reason that the court gave that would be served by public access to disciplinary type hearings. And the third reason was that like other administrative agencies, forms a part, however small, of a larger web of government authority. Free access to it informs the populace of the workings of government and fosters more robust democratic debate. So those are all the reasons. I mean, and in our case, and in this case, the reason public access is so important is that the respondents' disciplinary proceedings are toothless. They're ineffective. They allowed guards to form death squads that killed 2 prisoners in New York State. This process has to be brought into the sunlight, and that's what we're asking the court today. And with that, I'll reserve 3 minutes and 20 seconds for rebuttal. Thank you very much.
Thank you. Mr. Kiernan.
May it please the court, Beasley Kiernan for the respondent. Supreme Court correctly declined to grant the relief petitioner seeks, which is a declaration that DOC's disciplinary arbitrations are presumptively open to the public, and a writ of mandamus compelling DOCs to allow petitioner to attend certain arbitrations, because petitioner is not entitled to that relief under either the First Amendment or the common law. The test under the First Amendment is one of experience and logic, as Your Honor noted. First, courts consider whether the type of proceeding at issue has historically been open to the public. And second, courts consider whether public access is beneficial for that type of proceeding.
Mr. Kiernan, what do you say to his argument that says that you don't look at it in a purely historical framework? In other words, the first prong really has been expanded.
I take petitioner's point that you don't just look at New York case law, you look around the country. But you do look to history. You do look to whether this type of proceeding has historically been open to the public. That's what the U.S. Supreme Court stated in Press Enterprise. We think that's the right test. And historically, disciplinary arbitrations have not been open to the public. And even in the present day, they are typically not open to the public because arbitrations are quintessentially private proceedings. They are conducted by a third-party arbitrator resolving a dispute between an employer and an employee in this context, pursuant to the terms of a collective bargaining agreement, not pursuant to statute or court rules. When a state agency is involved in an arbitration, it is acting as a party, as an employer. It's not a government decision maker. It has no control over the outcome of the arbitration other than to challenge an arbitration award in an Article 75 proceeding. If the parties wish to allow public access to a disciplinary arbitration, they're free to do so, but petitioner cites no evidence or case law suggesting that disciplinary arbitrations are typically public. Now, disciplinary hearings, there's a bit of a divide. In some cases, the legislature has seen fit to open those proceedings to the public. For example, in matter of Doe versus Schenectady, this court explained that when Schenectady sought to discipline police officers pursuant to second-class cities law, section 137, those hearings were open to the public because the legislature explicitly stated that those proceedings are open to the public. In matter of Johnson newspaper, however, that involved disciplinary proceedings of licensed professionals. The legislature said that those proceedings are confidential, and the Court of Appeals held that there was no First Amendment right for the public to access those kinds of disciplinary proceedings. So ultimately, it is up to the legislature in a case like this. If the legislature wants to make disciplinary arbitrations open to the public, they're free to do so, but they have not done so. So petitioner fails at the first prong of this experience and logic test. Just briefly on the second prong of the text, there are important interests on both sides. Confidentiality does serve certain state interests. Keeping disciplinary arbitrations closed to the public encourages full and frank disclosure and testimony. It also prevents premature harm to employees who have not.
Okay, that's a terrible example. So your reasoning is that if they're public, the people are going to start lying? That's not great.
Not yet been found guilty of any misconduct. But again, ultimately, it's up to the legislature, because here there's no statute on point directing docs to open up disciplinary arbitrations to the public. There's no First Amendment right, and a petitioner has failed to show that he is entitled to the relief he seeks. A petitioner also mentioned matter of Harold v. Weisenberg, which was a common law case, and the Court of Appeals in that case explained that agency proceedings, judicial proceedings, are typically open to the public based on the strong public policy of public access to those kinds of government decision-making proceedings. Again, here we're talking about a private arbitration. There's no common law right to attend private arbitrations. Thank you.
Let me see.
No. I'm sorry. I thought cops were supposed to expose lawbreakers, not cover up for them. Private arbitration. This is Doc's contract with the prison guard union, 180 plus pages of it. It does not have a private requirement for private secret disciplinary hearings in the contract. This is a decision from the appellate division in Illinois, Chicago John Dean and Lodge versus City of Chicago. I provided a copy of this to counsel 2 days ago. And in that case, the appellate division ruled that an arbitration, a contract provision that made police disciplinary hearings secret in Chicago, violated the strong public policy of having hearings for serious misconduct open to the public. This is a quote. Law enforcement is charged with the duty of exposing crime, not concealing it. Just a word on the state constitution and the common law. Weissenberg creates a presumption, what he called the strong public policy of the state for access to administrative proceedings. The only way you overcome that presumption is with an explicit law that says hearings will be closed. That's the presumption that Weissenberg establishes. There is no law in New York that requires secret law enforcement disciplinary hearings. Therefore, the presumption of Weissenberg controls this case. This court in Dover, Schenectady, held that there was no law that prohibited law enforcement disciplinary hearings from being public. This court is bound by that decision. Now, in Mosher, another third department case, the third department unequivocally held that public worker administrative disciplinary hearings must be open to the public. This court wrote, this accords not only with the federal judicial tradition, but also to the general practice in administrative proceedings. This court is bound by Mosher versus Hanley, Your Honors. There is no dispute about this. Now, it's true that in Mosher, there was the issue specifically was whether the employee had the right to request access to the hearing. But the Supreme Court subsequently clarified, beginning in Richmond Newspapers versus Virginia, that the right to access was not just held by the worker. The or the right to access is held by the public and the press through an amalgam of speech, press, and assembly rights. And that's exactly what the Second Circuit Court of Appeals ruled in NYCLU versus the MTA, where the court ruled that journalists and the public had access to fair beater hearings as a matter of right. Previously, the MTA had conditioned public access on them obtaining consent of the accused fair beater. But the Second Circuit threw that out, said the hearings must be open, period. There is no requirement. Just one last word on the jurisdictional question about the declaratory judgment action. Under CPLR 103B, this court has the authority to issue any order it decides. So that jurisdictional question is really meaningless to resolution of the appeal. If there's any questions,
No, thank you both.
Thank you very much.
Yeah, that was interesting.
No,
what?
Describe the process of
no evidence. Zach Adams was
being
involved
retained
in Holly Bobo
by
death.
Zach Adams.
Well, I was.
Oh, that's concerning. Okay, I'm gonna stop streaming because my computer's like not working right now. It keeps like flashing back and forth between different windows. So I'm gonna call it a night. I'll probably stream again soon. I just finished moving a little while ago, so that's why I wasn't streaming so much. I finally have everything more or less set up the way I want it, except for the monitors and the computer not working. But other than that, it's been pretty good. But yeah, thanks to everybody for tuning in. I'm not sure what I'll do next. I think I'm going to keep doing my little Moontung series because I have plenty more things to do videos. Plenty more topics for videos on that subject. But yeah. My chat is being all weird. Oh no, not this lady. Wait, wrong. See, I didn't even see any of that. I couldn't even get my chat to come up. Okay. Psychedelics. Yeah. You need another monitor? I do. I need to buy one. Reacting to bad legal I'm banned. I'm banned from multiple legal advice subreddits because I give correct legal advice. Oh, I used to. And I would occasionally say things that the experts found offensive, because the legal advice on there is straight garbage. It's every single time it's wrong. It's just people that want to sound authoritative but have no idea what they're talking about. And 9 times out of 10, the advice is you're screwed and you're an idiot and you're stupid and you should feel bad. And meanwhile, it's nah, they're definitely not. But yeah, so I would be yeah, everyone here is a fucking moron. Don't listen to them. Listen to me. And apparently that offended some people. I don't know why, because I'm not even sure they could read. But in any event, I am banned from legal advice, and I don't know which other ones. There's actually one day I'd actually just done oral argument in the same day. In the morning, I had done oral argument in a case, and then in the afternoon, I found out that I had won an appeal that I'd actually forgotten about. The Court of Appeals just decided in my favor without a hearing or anything. And then after that, I got a message from a legal advice Reddit mod telling me that I didn't know what I was talking about. God, this was 2 years ago. I'm still mad at that guy. God, that guy sucks. You're not serious. Oh my goodness. Maybe instead of law and crime trolling, I should just do Reddit legal advice trolling. All right. Enough ranting about that. I'm going to call it a night. And yeah, thanks everybody for tuning in. Definitely watch Kat's thing on Zachary Adams tomorrow. I actually had a friend named Zach Adams growing up, and so that's been kind of weird for me. Yeah, I bet. Oh, man. Okay, I'm going to work on emojis too, probably at some point. But yeah, thanks for coming, everybody.